The committee will come to order. The Oversight Committee's mission statement is that we exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It's our job to work tirelessly in partnership with citizen watchdogs and whistleblowers to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. Before I deliver my opening statement, because we have Senator Grassley here, I'm going to ask unanimous consent that the IG report released last night entitled Department of Health and Human Services IG Report Review of the Food and Drug Administration's Computer Monitoring of Certain Employees in its Center for Device and Radiological Health be placed to the record. Without objection, so ordered. Additionally, I ask that the joint staff report entitled Limitless Surveillance at the FDA Protecting the Rights of Federal Whistleblowers be placed in the record.
Chairman.
Yes.
I have no objections, but I just want to make sure it's clear that that is the staff report of the Republicans. Is that right?
It is a joint report of the House and Senate Republicans.
House and Senate. So the Senate Democrats were not involved.
In
this report, the Senate Democrats.
This report is a result of a investigation in which all your Democrats staff were in there, but we did not ask for or provide a long comment period to your people. You're entitled to place a minority staff report at your convenience. You have the same information.
No, we will definitely do that.
Great.
I just wanted to make it clear on the record.
Absolutely.
Right.
Without objection, so ordered. They're both in the record. And I'll place my entire opening statement on the record and be brief. Today's hearing is about a questionable practice at the FDA, one that has been under investigation for over 2 years, or almost 2 years, July of 2012, by the Inspector General, one that we do not consider to be political in any way, shape, or form, or partisan in any way, shape, or form. We consider it to be questionable, if not despicable, that whistleblowers, a known whistleblower and others, appear to have been targeted for an investigation, proactively monitoring, effectively a wiretap on their computers in order to see if they could get the dirt on employees so that they could take action. The FDA justified this based on a leak to the New York Times. However, to the best of our investigation, rather than working retrospectively to see if they could discover who had in the past leaked, they began a practice of monitoring computers, one that captured all information, forwarded all information, including, at a minimum, correspondence as whistleblowers with 3 members of Congress's staff, Senator Grassley's, our staff, and Chris Van Hollen of Maryland. It doesn't matter whether it's one or all. It doesn't matter whether it's a Republican or a Democrat. This committee believes in whistleblowers, encourages whistleblowers, and particularly believes that communications with members of Congress, the other branch, Article 1, are in fact off limits to that kind of monitoring. It appears as though no protections were placed on that, but rather this was an attempt at gotcha. There may have been good reason to be concerned. An investigation into leaks may have been very justified. In this case, we are not questioning whether or not an investigation should have occurred, but rather the tactics and the lack of protection there. Today, we're holding this hearing, and we're pleased to welcome Senator Grassley, whose investigation really kicked this off and whose staff has worked hand in hand, along with the Democratic members of this committee staff, on hearing all of the witnesses. I might note, during the period of July 2012, when this began till now, whistleblowers involved in this have been reticent to go on the record. They have wanted to deliver with as few people hearing what they have to say as possible, and then let the facts speak for themselves. In the purest sense, that's what whistleblowers should do. In the purest sense, we should have an independent investigation that discovers the facts with limited testimonial by the whistleblowers. Their concern when they're reporting essentially whistleblower retaliation is certainly understandable. Neither the IG nor the minority on this committee has had an opportunity to speak to those whistleblowers. I will continue to encourage them to speak to both the IG and minority staff. But it is their decision. A whistleblower may come to one member of Congress, any one member of Congress, in my opinion, and that member of Congress should proceed on his constitutional or her constitutional responsibility and protect the whistleblower to the greatest extent possible. This committee will also always support that protection. The misconduct that we are looking at isn't just overreach. It mirrors a famous book and movie ripped from the pages of George Orwell's 1984, constant monitoring of your screens. The only thing that was missing, of course, was a camera looking both ways. I am here to say that the Federal employees know that every communication they do on a government property, on government time, or using government assets, or doing government business is subject to the Federal Government looking at it. There is no expectation of privacy. But that is not to say that targeting is appropriate. It is not to say that these 5 scientists and doctors' concerns are not reasonable. They are. If there is a reason on behalf of the government to look at the use of government assets, government communication, of course we expect the executive branch to do that. However, if there is going to be use of products such as Spectre 360, a product that captured every 5 seconds the screens of the computers being used and the keystrokes, then quite frankly, it has to be done for all at every moment, and then there have to be rules on how it can be used. I am not suggesting that, just the opposite. The Federal workforce is a highly trusted force, and trust is what we depend on. At times, it is clear that that trust is broken, and when it is, there are appropriate remedies. But until that trust is broken, we depend on a skilled and motivated workforce that believes, as they should, that they are not working for Big Brother, that in fact they are trusted in their roles and not being unreasonably spied on or targeted for disciplinary action. For that reason, we are holding this hearing today not as just an indictment of the FDA, which I think Senator Grassley will speak to, but as a recognition that all Federal employees need to be protected from an unreasonable activity which, at least in this Chairman's opinion, is part of what went on at the FDA in targeting these 5 whistleblowers. Again, I will put the rest of my opening statement in the record, and I yield to the Ranking Member.
Thank you very much, Mr. Chairman. Today, we examined 2 distinct but related issues. First, we will review allegations that the FDA employees leaked trade secret and other confidential business information from companies seeking FDA approval of medical device applications. We will also review allegations by these employees that they were whistleblowers concerned about the safety of these medical devices and that the FDA retaliated against them by monitoring their computers. Whistleblowers play a critical role in rooting out waste, fraud, and abuse at Federal agencies and making our government more effective and efficient. They sometimes risk their careers. They sometimes risk their reputations to challenge the abuse of power. And our committee must take every allegation very seriously with regard to retaliation. I have said it before, and I'll say it again. we must, at every point, protect our whistleblowers. I am committed to that, and we are all committed to that. Unfortunately, the majority has taken a traditionally bipartisan issue, something that all committee members should be investigating together, and turned it into another partisan spectacle for which our committee has become well known. One of the most basic steps of our committee should have taken was to interview the FDA employees who had concerns. I remind all of us that everybody on this side of the aisle and everybody on that side of the aisle represents 700,000 people each. Every one of us, the 435 members of our Congress. As a foundation for a responsible investigation, we should have met with them, asked them questions, learned about their concerns, and given them an opportunity to address evidence that may contradict their accounts. Instead, despite multiple requests from the Democratic side over the past year, the chairman declined to hold interviews with these employees, although he and Senator Grassley apparently have been communicating with them directly. These employees were never called in for standard committee interviews. And I heard what the chairman said, but at the same time, as I have said, that we need to have an opportunity, just as Senator Grassley has, to talk to these folks, just as the chairman has. As a result, most committee members have no opportunity to talk to these employees and will not have the benefit of their input as we proceed. Again, we're talking about effectiveness and efficiency, talking about transparency with regard to the members of the committee. The chairman also chose to issue a highly partisan Republican staff report this morning. Just to be clear, this is not an official committee report. It did not follow committee rules for an official committee report. It was not vetted for accuracy by the committee. Also, unfortunate was the timing of today's hearing. Over the past month, the Inspector General was finishing his own investigation and was poised to issue his report on this issue. Rather than wait a week or two so the committee could hear directly from the IG, the committee rushed to hold today's hearing, apparently trying to beat the IG to the press. As a matter of fact, the press got the report before we did, their report. It is interesting that we have a situation where the IG was able to complete his report, and he provided it to the committee last night. Now let's look at what the IG found. First, the FDA, and I quote, this is the IG, had reasonable concern that confidential information, including possibly trade secrets and or CCI, had been disclosed by agency employees without authorization, end of quote. Companies that submitted applications had asked the FDA to investigate which employees leaked their trade secret and confidential commercial information in violation of the law. The IG found, and I quote, that the FDA had provided notice to its scientists and all other users of the network through a network log-on banner that there was no right to privacy on the FDA computer network and that all data on the network was subject to interception by the FDA, end of quote. The committee's investigation has identified no evidence that the FDA monitored employees to retaliate against them. The agency had a reasonable basis for initiating the monitoring since the disclosure of proprietary information is prohibited by law and subject to criminal penalties. The IG also found that regardless of whether the computer monitoring was allowable under the law, the FDA did not have sufficient safeguards to ensure that monitoring would avoid collecting communications with Congress, the Office of Special Counsel, or the IG. As I close, despite the reasonableness of the FDA's concerns and its explicit warnings that employee computers could be monitored, the IG found that the FDA, and I quote, should have assessed beforehand and with the assistance of legal counsel whether potentially intrusive in-case inspector monitoring would be the most appropriate investigative tool and how to ensure that the use of these tools would be consistent with constitutional and statutory limitations on government searches." End of quote. The FDA has now implemented new policies that require written authorization from the Chief Operating Officer to initiate monitoring and a legal review of the proposed monitoring by the Chief Counsel, including a determination that proposed monitoring is consistent with the Whistleblower Protection Act. Protecting the rights of whistleblowers is an issue we should all be working on together, and our committee has done so in the past. In 2012, this committee passed the Whistleblower Protection Enactment Act, which was signed into law on November 27, 2012. This is strong evidence that when the committee operates on a bipartisan basis, we can accomplish very important and even groundbreaking accomplishments. I hope we can return to the type of bipartisanship in the future. I look forward to hearing from the witnesses. Mr. Chairman, I thank you for your indulgence.
Of course. I now ask unanimous consent. The letter dated February 25th by me to the ranking member be placed in the record. Without objection, so ordered. Mr. Cummings, I might note that the IG report, which came out at 4:30 last night, was preceded by the staff report being given to your staff, which contains substantially all of the same information as the IG report. And we noticed on January 14th, the FDA, of our plan to have today's hearing. At that time, we had no expectation that the IG was going to conclude, and in fact, in a Herculean way, the Administration managed to respond to the IG's comments in 2 days, and the IG managed to get it out last night. We're proud of the fact that that report would not have been in our hands today had we not been scheduling this hearing.
Well, Mr. Chairman, the gentleman yield?
Of course.
I think the IG and the administration wanted to get that report out because it felt that it would be significant with regard to any hearing that we might hold. And so, therefore, those who might have commented from the administration reserved comment so that they could get the report out, because we know that all of us have tremendous confidence in the IG. And I guess, going back to efficiency and effectiveness, that if we have an IG report, an independent agency that has looked at these things very carefully, it would be nice to have that report for the hearing. To me, that's effectiveness and efficiency.
And the good news is we do have it. I might note, by the way, that I never spoke to any whistleblower. We can certainly ask Senator Grassley. I never spoke to them directly.
Did your staff?
As you have said so many times, Mr. Cummings, the book, The Speed of Trust, is about trust being earned. The whistleblowers were unwilling to meet with members of your staff because they did not trust that this would not turn into retaliation. That is through their attorneys, and they are represented by counsel, what we have been told. So my staff encouraged them and has in no way dissuaded them from talking to your staff, and I openly this morning encourage them once again to come and meet with them. But quite frankly, since this hearing is about inappropriate, now determined by the IG, to be inappropriate targeting of whistleblowers using questionable tactics, you can understand why the whistleblowers, whom, to my knowledge, I don't know, but they may or may not be some of the people targeted here, are reluctant to be prosecuted, persecuted, and triggered again by an agency that they do not personally believe in. They do not trust their agency, and they do not trust those who would report back to their agency. That's not my fault. That's not your fault. But that's the reality that the whistleblowers have.
Could we not have brought them in for interviews?
Yes, I could haul in whistleblowers and expose them.
We haul in people all the time.
I could expose them to the administration knowing about them and then retaliating against them. I could do that. But I will protect whistleblowers' right to give us information. Without their testimony, we have independently, and the IG has independently reached the conclusions which we will see today. So I think the record speaks for itself. Whistleblowers made Senator Grassley and his staff aware of a problem, but independent investigation by the IG and by this committee, bipartisan investigation, have led us to the conclusions we will hear today. And by the way, the hearing is not about the leak of information. It's about the unreasonable retaliation. I might caution you that we did not investigate the specifics of the leak of this material. It is certainly a knowledgeable fact, But our investigation began in the retaliation, not in that.
Just one more inquiry.
Of course.
I know Senator Grassley is limited.
He's been
on time.
patient, and his time is limited.
This is a question. Life is short. And so you just said that you didn't look at the allegations made by the whistleblowers. Is that what you're trying to say?
No, the whistleblowers made allegations that led to an investigation. Senator Grassley, I'm sure, will cover this. The investigation independently determined what they had said. We are not relying on their allegations. They are not fact witnesses for purposes of the IG, Senator Grassley's staff, or my staff. The result of both the pieces of paper, the packets you have, are the result of independent, the IG and your staff and my staff and Senator Grassley's staff interviews. We did not need the whistleblowers except to be aware of a problem. The investigation is complete and does not need further testimony. In other words, there was no reason to expose the whistleblowers to the possibility of retaliation because their allegations have been confirmed independently. You believe it, and I believe it, and the IG believes it, that this retaliation that was done against these 5 people was, in fact, done.
Gentleman yield.
Of course.
The only thing I'm getting to is that, and Senator Grassley, I'm sure will address this, if there is equipment being used in hospitals that is defective, that people are getting diseases from, we got 2 issues here. I want to make sure that we deal with that because we can get so caught up in the political stuff that we forget the people who are the victims of some of this, one of which, I don't know whether it was from equipment, but I just had a constituent to die after giving birth to twins from disease that was contracted in a hospital this week. So I'm trying to figure out, we got 2 parts here. We got the whistleblowers, and I think the reason why the whistleblowers bring information to us is so that we can do some reform. Remember, that's a part of our title, and try to make sure that the constituents that we serve are safe. So you're saying that we will not get to that piece of it?
No, not at all. I'm saying that the investigation was as to the retaliation. Dr. Smith, who was a qualified whistleblower, had deep concerns about the FDA's process and validity of medical devices they certified, and he made allegations that the FDA was not doing their job properly. That's the initial whistleblower activity, which was not disputed. The leak justified in the FDA general counsel's mind, which makes me question whether or not these reforms are of any good when the general counsel was receiving the information, made them believe that they could monitor 5 employees prospectively on everything, including their communications with Congressman Van Hollen, Senator Grassley, and my staff. That is what we're researching today. I'm not qualified, quite frankly, to look at the allegations of medical device effectiveness, and I don't believe his initial claim came to our committee on the invalidity of the medical devices. But Dr. Smith, who's not a witness here today and is not part of it, was a qualified whistleblower. He had complaints and he was making them. The investigation was supposedly not about his whistleblowing, but he became the target when they said that there had been a leak, which apparently there had. And I'm perfectly happy to have people drift off onto the question of the leak in the New York Times, but what we do know is although leaks to the New York Times occur all the time, we have whistleblower retaliation in the unreasonable, if you will, activities in the opinion of the IG and in the opinion of this committee staff report. And that's what the primary reason for the hearing is we do not want to have a chilling effect on potential whistleblowers, but more importantly, you and I know that we have to and better trust our Federal employees and not be spying on them 24/7, even though we have a right to look at the material on which they work if necessary.
As I close, let me just say this. You talked about the speed of trust, and I don't want anybody watching this or hearing this to be left with the impression that folks on this side of the aisle, including our staffs, are some kind of way not protective of whistleblowers. I don't want that getting out into the universe. because it's simply not true.
And Mr. Cummings,
I would never say that.
I'm not asserting that you're not trustworthy. What I'm asserting
and my staff
is that the whistleblowers were unwilling to. And I have been corrected on one thing. In 2009, under Chairman Towns, Dr. Smith provided thousands of pages to this committee in support of his whistleblower allegation. So that is really the beginning of Dr. Smith's activity as far as this committee goes. And he was a qualified whistleblower, having come to Chairman Towns and this committee with his concerns, and I think other committees, with his concerns about the FDA's activity. And again, even though I also serve on Energy and Commerce, I'm not claiming that I can understand the details of his allegations. And I would like to the greatest extent possible, caution all members to primarily look at the question of whether the activities at the FDA pursuant to their trying to find a leak crossed a line and interrupted and would have a chilling effect on whistleblowers, which I think is what our committee's primary jurisdiction is.
And, Mr. Chairman, which is my primary concern also.
Okay. Senator Grassley, you've been incredibly patient. You've heard more testimony than you planned to. And with that, such time as you may consume.
Before I read, I would like to say a couple things.
Our mics on this side don't amplify as well. They need to be much closer. They're house mics.
Two things I'd like to say before I read. One, generally about whistleblowing. In 33 years, under both Republicans and Democrats, I've found the problem the same, whatever bureaucracy you're talking about. Whistleblowers are about as welcome in a bureaucracy as skunks at a picnic. There's a great deal of peer pressure to go along to get along. And then specifically in regard to the FDA, just so everybody knows, we have a Democrat president, but going back to 2003, when I first got involved with whether or not the scientific process was being respected within the FDA, and respected scientists coming forward. First was Vioxx, and then several things since then. We have found problems with the respect of scientists and the respect of the scientific process within that agency, regardless of who was president. Thank you, Chairman Issa, for calling this important hearing and for the great work that you and your staff have done. Together, we have conducted a detailed investigation into the FDA aggressive surveillance of whistleblowers. A group of FDA scientists expressed concern about the safety of certain devices under review by the agency. They expressed their concern to the President's transition team and to Congress. They also contacted the Office of Special Counsel, which is an agency, as you know, created by Congress to receive whistleblower complaints and protect whistleblowers from retaliation. The FDA knew that contacts between whistleblowers and the Office of Special Counsel are confidential and protected by law. However, the FDA was intently spying on whistleblowers. There was no effort to avoid snooping on legally protected communications. This surveillance was much more intense than routinely monitoring of government employees on government computers. It was far more invasive than what would be necessary to detect inappropriate use of computer systems. The agency captured a picture of whatever was on the screen every 5 seconds, as you've said, and recorded every keystroke typed. Again, the FDA did not monitor every FDA employee this aggressively, just the whistleblowers. When we first spoke to the FDA in January 2012, they tried to dodge the issue. When I started asking questions, FDA officials seemed to suffer from a sudden case of collective amnesia. It took the FDA more than 6 months to answer my letter asking about its surveillance of its own employees. When I finally received response, it didn't even answer the simplest of questions, such as who authorized the targeted operation. Worse than that, it was misleading in its denials about intentionally intercepting communications with Congress. When I asked them why they couldn't just answer some simple questions, they told my staff that the response was under review by, quote, the appropriate authorities in the administration. The FDA's non-answers and doublespeak would have fit right into some George Orwell novel. The work our staffs have done together uncovered answers to many of those initial questions. Today, we will hear from some of the FDA employees involved in the surveillance. There can be legitimate reasons to monitor the use of government computers by government employees. However, as our joint report shows, FDA officials gave little, if any, thought to the legal limits that might restrict their power to monitor their employees. No one at the FDA made any attempt to limit the collection of legally protected communications with attorneys, with the Office of Special Counsel, or with Congress. The FDA trampled on the privacy of its employees and their right to make legally protected disclosures of waste, fraud, and abuse. These whistleblowers thought the FDA was caving to pressure from the companies that were applying for FDA approval. I don't know whether they were right, but they have a legal right to express those concerns. After expressing their safety concerns, 2 whistleblowers were fired. 2 more were forced to leave FDA, and 5 of them were subjected to an intense spying campaign. At the beginning of the FDA Commissioner Hamburg's term, she said that whistleblowers expose critical issues within the FDA. She vowed to create a culture that values whistleblowers. By the way, that's a promise I've had from several people predecessor to her coming to my office wanting confirmation and making those same promises. In fact, in 2009, Commissioner Hamburg said, and I quote, "I think whistleblowers serve an important role," end of quote. I wanted to believe Commissioner Hamburg when she testified before the Senate during her confirmation. I wanted to believe her when she said she would protect whistleblowers at the FDA. However, in this case, the FDA was certainly not a whistleblower-friendly place to work. And I've spoke about how that's been the case since, at least my involvement, since 2003. The FDA managers believed that the whistleblowers were leaking confidential information improperly. But the managers who claimed that there were many other problems with the job performance of the targeted employees. Performance issues, of course, should be handled by directly supervising and managing employees. Instead, the FDA asked the HHS Office of Inspector General to investigate whether the employers had violated the law. The Inspector General declined on multiple occasions, but FDA managers kept asking for a criminal inquiry. Rather than simply managing its employees, the FDA then started spying on them. The managers kept looking for information that would convince the Inspector General to seek criminal prosecution. It was sort of management by investigation. And of course, that's no way to run an agency. According to the OIG and later the Department of Justice, the FDA had no evidence of any criminal wrongdoing by the whistleblowers. None whatsoever was ever found. The FDA spent months using intrusive real-time surveillance of their employees' computers, looking for evidence of a crime. That time and effort would have been better spent supervising and managing the employees directly and making sure the employees were doing their job and not bothered from doing their job. The FDA claimed that their employees had no expectation of privacy on their FDA computers. However, when interviewed by congressional investigators, none of the FDA officials were willing to accept full responsibility for authorizing the surveillance. Apparently, no one was properly supervising this invasive surveillance program. The monitoring software used was so comprehensive, it took countless hours just to review all the material. It was a detailed record of everything each of the scientists did all day, every day, for months. Hundreds of thousands of screen images had to be reviewed by FDA contractors, all at taxpayers' expense. So what kind of legal guidance was provided to these contractors about what they could capture? None. We would not have known the full extent of the spying today if the FDA had not accidentally released 80,000 pages of fruits of its spying on the Internet. Talk about adding insult to injury. after collecting all of this information in an effort to supposedly prevent leaks, the same agency ends up posting all of those documents online for the world to see. In these internal documents that FDA never wanted the public to see, it referred to the whistleblowers as collaborators. So you understand what I mean when I say whistleblowers are about as welcome in an agency as a skunk at a picnic. FDA referred to our staffers as ancillary actors, and they happen to refer to newspaper reporters as immediate outlight actors. Let me tell you, you wouldn't be doing any congressional investigation. Well, you might do a little bit because we could obviously ferret out some, but we wouldn't be doing 90% of what we do on protecting whistleblowers and congressional oversight if it wasn't enterprising newspaper or media people or whistleblowers coming forth with some things that they find wrong that we don't even know where the skeletons are buried in the bureaucracy of this big government of ours. But anyway, so they're collaborators, they're ancillary actors, or they're media outlet actors. The FDA claimed it was a mistake made by the company it hired to convert surveillance records for legal review. And of course, that wasn't true. The FDA incorrectly filled out a purchase order for the work. The FDA did not mark the documents as confidential or sensitive, and it didn't even fill out the form until after the work had been done. Our inquiry uncovered no record that the private contractors was told that the documents were sensitive. So, the FDA failed to classify these documents as sensitive and then tried to blame the small business company that it hired to convert the documents. This is a scene that comes up time and time again in this entire story that you're looking into today. The FDA has failed to accept responsibility for its actions or impose accountability. This is from an agency that purportedly wants to foster a culture where whistleblowers are valued, based upon Director Hamburg's testimony to our committee. The FDA's actions are, of course, disappointing. Not just disappointing because of the history that we're now, of this history, but over a long period of time, and it was supposed to change when this commissioner was appointed. But it would be even worse if that agency fails to learn from its mistakes. And since 2003, and maybe people before me would say the same thing, would say that they've been looking for learning from the mistakes of the past. Doesn't seem to happen. And most of these are just simple respect for the scientific process, because you can leave, if you leave the politics out of it and let scientists do it, the scientific process of one science checking on another scientist's work will prove itself, or that scientist isn't going to be worth anything. These policies need to ensure that any monitoring is limited to achieving only the legitimate purpose. Watching on employees every minute leads to a culture of intimidation and fear, which not just the FDA, but bureaucracies generally want whistleblowers to know about so that they don't tell what they know is wrong. And of course, that's no way to encourage whistleblowers, or it's no way to show that you value their concerns. I thank you very much.
Thank you. And if you would take a few questions from the ranking member, I'd appreciate it.
Yes.
Mr. Cummings.
Thank you very much, Senator Grassley. And I really do thank you for being here today. Thank you for your patience. I have the utmost respect for you and your legacy as a champion of whistleblowers and whistleblower protections. And I really, on behalf of the American people, I thank you.
Thank you.
As I said earlier, this has not traditionally been a partisan topic, I don't think. You and Senator Akaka both sponsored the Whistleblower Protection Enhancement Act, and Chairman Issa and I sponsored the House version of that bill. I assume you agree that we accomplish much more when we are working together. Would you agree with that?
I have found.
I heard what you said about the skunk and all that. Yeah. But
yeah. Well, listen. I think your question is trying to put me between you two people, and I don't relish being.
Well, let's say has it worked in the Senate?
I have found in the United States Senate. I don't want to talk about the House of Representatives. I found in the United States Senate that not a whole lot gets done if it's not done in a bipartisan way, but that's because our two institutions are different. We function under a 60-vote rule that requires when you have 55 of one party, 45 of the other, you got to do something in a bipartisan way. And I've also found as a member of the minority that it makes a real difference who's chairman of the committee. When I was working with Senator Baucus on the Finance Committee, and he was in the majority, I didn't get much response from any administration without the help of the chairman.
Have you had an opportunity to talk to the whistleblowers?
We have only talked to their attorneys.
I see. And Chairman Ice and I had a good discussion this morning prior to the hearing. And one of the things that he raised, and I agreed, it seems like this, and I want the witnesses to hear this. It seems to me that the issue comes down to this. When, first of all, there was a situation which screamed out for somebody to look into it. In other words, New York Times writing articles with trade secrets. It seems like the agency had a duty to at least look into it. Would you agree with that?
Would you please ask your question again?
In other words, the way this whole thing started apparently are some stories in the New York Times with trade secrets in the New York Times that weren't supposed to be there.
Okay.
And so I think it started off legitimately saying, okay, we've got a problem here because this information is not supposed to be in the New York Times. So would you agree that that at least starting, that they had something that they needed to look into? Now, I'm not saying they did it right. I'm just asking you.
Okay. I'm not sure that I can answer your question.
Okay.
But let me see if I can speak to it and give you some satisfaction. I think it gets down to a point of whether or not the information was accurate or not that these whistleblowers were talking about. We have not looked into the accuracy of that information. We've only looked into it from the standpoint that some people say there's some problems, and that's where you get back to the point that I've made a couple times, not about the skunk, but about the scientific process, that if we want an environment within the FDA where the scientific process works its way out and not interfered by people that aren't scientists or involved in that process. And I'll only go back to one other instance a long time ago. But we have found that in one instance, years ago, we found email from industry that said, well, if you got a problem with our product, talk to us. Well, the point is that the FDA should not consider a manufacturer or a company across the table from them. The only people that should be across the table from the FDA scientists or regulators are the John Q. public.
Okay, and so in this case, a group of FDA employees allege that certain medical devices may have safety problems. Now, if their allegations are correct, that is obviously a huge problem for everyone who relies on these types of medical devices when they become ill or get in an accident. On the other hand, if these allegations are not correct, these FDA employees could be doing damage. They could be keeping safe medical devices off the market and out of the hands of doctors who use them to help people. And I think that you would agree that if devices should be on the market to save people's lives and make them better, they ought to be there. Would you agree with that?
Well, the answer to that is yes, but how do that decision made?
And that is,
it's not going to be made by us in Congress.
I got that.
It's going to be made by the scientific approach.
Just one more question, Mr. Chairman.
In the FDA.
Let me just get to this, the key question that the chairman and I were discussing this morning. It seems to me that if they had done this, the investigative folk had done this in a retrospective way as opposed to a prospective way, we probably would not have the issues, as many issues as we have today. Do you think?
Well, yes, but I have to surmise, because I can't answer your question, but I have to surmise the reason it worked out the way it worked out is people weren't getting the proper respect within the agency for their opinion.
I see.
And their opinion could be wrong, but the scientific process is going to prove whether or not they were right or wrong.
Well, I want to thank you for being here. Yeah. I really appreciate it.
Thank you.
And look forward to working with you.
Please do.
Yeah, we need to get together and meet sometime.
I'll take you to eat in the members' dining room, and I'll pay for it if you want to take me up on that.
All righty. Thank you.
Senator Grassley, we know how hard it was for you to say that.
and it hurt, but since I said it, I'll have to do it.
Thank you. Thank you. We're going to take just a quick recess to set up the NABLE. Thank you, Senator. We now welcome our second panel. Dr. Jeffrey Shuren is the Director of the Center for Device and Radiological Health at the FDA. Ms. Ruth McKee is the Associate Director for Management and Executive Office and the Executive Officer of the Center for Device and Radiological Health at the FDA. Mr. Walter Harris is Chief Operating Officer and Acting Chief Information Officer for the FDA, and presumably the person that would approve such an activity in the future under the rules. And Ms. Angela Canterbury is the Director of Public Policy for the Project on Government Oversight, or POGO, and we welcome all of you. Pursuant to the committee's rules, for any non-senators or House members, would you please rise and take the oath? And please raise your right hands. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. I'll let the record reflect that all witnesses answered in the affirmative. In order to allow time for questions, I would ask that you be as close to 5 minutes as possible in your opening statements. Your entire written opening statement will be placed in the record. And Dr. Shurin, I understand you do not have an opening statement. Is that correct?
That is correct.
Okay. In that case, we go to Ms. McKee.
I don't have one either. Mr. Harris is speaking.
Okay. Mr. Harris.
Good morning, Chairman. Chairman Issa, Ranking Member Cummings, and members of the committee. I am Walter Harris, the Deputy Commissioner for Operations, Chief Operating Officer, and Acting Chief Information Officer at FDA. With me is Dr. Jeff Shurin, the Director of FDA's Center for Devices and Radiological Health, and Ruth McKee, CDRH Associate Director for Management. I am pleased to be here today to discuss issues related to the monitoring of FDA's personnel's use of the agency's IT systems. Safeguarding the confidential information that regulated entities share with FDA is critical to our ability to carry out FDA's public health mission. FDA routinely receives and reviews trade secrets and confidential commercial information from medical product sponsors. This information is central to FDA's determination of a medical product's safety and efficacy. Without the ability to fully access and secure this proprietary information, FDA could not accomplish its public health mission. FDA employs security controls throughout our IT enterprise, including the monitoring of FDA personnel's use of government-owned equipment. This and other IT controls supports protections of intellectual property entrusted to FDA from theft or sabotage. Unauthorized disclosures of information not only violates federal law and regulations and undermine the integrity of FDA programs, they also can result in civil suits against FDA. So it is critically important that FDA protects against unauthorized disclosure of such information by agency personnel, and for the FDA to appropriately investigate any suspected incidents of unauthorized disclosure. FDA personnel are regularly advised that they have no reasonable expectation of privacy when using FDA computer networks, and that any use of agency IT resources, including email, may be monitored. This notice is provided by a variety of means, including a warning banner that an employee must acknowledge every time he or she logs on to the FDA network, which clearly states that by logging onto the system, the user consents to having no reasonable expectation of privacy regarding any communications or data in transit or stored on that system. All FDA users are also made aware of HHS policy that any use of HHS email may not be secure, it is not private, it is not anonymous, and it may be subject to disclosure, and that employees do not have the right to, nor expectations of privacy at any time while using HHS IT resources. Although FDA has clear legal responsibility and authority to monitor personnel use of agency IT resources, we must carry out such monitoring in a way that recognizes employees' interest and legal protections. In 2010, FDA suspected that 5 CDRH employees were using FDA IT systems to send trade secret or confidential commercial information outside of FDA in possible violation of FDA regulations and criminal laws. To investigate the suspected leaks, FDA employed computer monitoring software on those employees' government-issued FDA computers. The computer surveillance is currently the subject of ongoing litigation. In 2012, the HHS Office of Inspector General, or OIG, was asked to assess whether that monitoring was appropriate and to provide recommendations on how FDA should investigate allegations of improper dissemination of confidential information. Yesterday, the OIG issued its report. Significantly, the OIG found that the CDRH had reasonable concerns that confidential information had been disclosed by the monitored employees without authorization. The OIG also found that FDA had provided notice through the network login banner those employees that the use of their FDA computers would be monitored. The OIG found no evidence that FDA obtained or used passwords of any employee's private email accounts. And the OIG found that there were no evidence suggesting that FDA monitoring was designed to capture communications with any particular person, group, including Congress. Yet we understand that we must have adequate procedures in place when conducting such monitoring. Indeed, since 2012, we've been reviewing and evaluating our policies for monitoring the use of government-owned computers to ensure they are consistent with the law and with Congress's intent to provide a secure channel for protected disclosures. In September 2012, Commissioner Hamburg directed FDA leadership to adopt policies for requests to monitor FDA computers to make sure that any monitoring is justified, narrowly tailored, and duly authorized, that data derived from monitoring is appropriately stored and controlled, and that monitoring is used for appropriate purposes and takes place for no longer than necessary. Last September, we issued our interim computer monitoring policy. This policy provides standards when employee computer monitoring takes place. It established a special committee to review monitoring requests. It requires that monitoring requests be narrowly tailored in time, scope, and degree. It requires that all requests identify the least invasive approach. It also requires considerations of alternative methods to address the potential risk. Provide documentation standards and state that no computer monitoring may target communications with law enforcement, the Office of Special Counsel, members of Congress, union officials, or private attorneys. Notably, yesterday's OIG report acknowledges that our September 2013 interim computer monitoring policy addresses all of the OIG's recommendations. In order for FDA to effectively carry out its public health mission, we must be vigilant to protect against the misuse or unauthorized disclosure of confidential information that is regularly entrusted to the agency. We believe that the policies and procedures we have in place appropriately and effectively balance the individual interests of employees with FDA's critical needs to safeguard the security and integrity of data and IT systems that the agency is entrusted to manage. Thank you for your commitment to FDA's mission and for the opportunity to testify today about the monitoring of FDA's employees' use of agency IT resources and FDA's responsibility to secure medical product sponsors' confidential information. I'm pleased to answer any questions.
Thank you. Ms. Catterberry.
Thank you and good day, Chairman Issa, Ranking Member Cummings, members of the committee. The FDA spied on whistleblowers, which set off a firestorm that led us to this hearing today. But the public story of whistleblowers began in 2008 when FDA physicians and scientists warned Congress and shortly thereafter the President that the process for approving medical devices was broken, allowing potentially ineffective and unsafe products to be marketed. And as Senator Grassley noted, there have long been problems with bureaucrats at the FDA respecting the scientific process. The report released today by Chairman Issa and Senator Grassley and the HHS IG report document how FDA surveillance of whistleblowers was reckless and heedless of legal limits and whistleblower protections. Certainly, security concerns and available technology will outstrip constitutional rights and whistleblower protections unless Congress works to balance those goals. To be frank, we question why FDA should be in the surveillance business in the first place. The FDA's mission is to ensure our food and drugs and devices are safe. Any suspicion of unlawful disclosures of information or criminal misconduct should be investigated by law enforcement. Federal agencies cannot be allowed to police themselves, and that is why we have IGs, the OSC, the FBI, and Congress. Even with just cause and proper controls, it will be difficult, if not impossible, to protect whistleblowers if agencies are allowed to gather electronic evidence without limits or oversight. And to what end? The Issa Grassley report shows the leaks of confidential information to the press were not confirmed by this pervasive, invasive electronic surveillance. And so, as with the NSA domestic surveillance, the risks to our rights may be greater than the ability of the surveillance to protect against risks to security, much less claims of harm to trade secrets or harm to profits. No doubt the FDA is in a tough spot, attempting to put into place a process that is more prescribed for surveillance critics, but also placating the lawyers for drug and device companies that demand that information be kept confidential. Needless to say, the FDA does not have it right yet. Rather than protect whistleblowers from unwarranted FDA surveillance, its interim policy protects the FDA from whistleblowers. It shields it from accountability. Nothing in the FDA's interim policy would prevent FDA managers from using information collected by the surveillance as retaliation for whistleblowing. Thus, this policy does little to lift the chilling effect that fosters wrongdoing. How can the FDA ensure the public's health and safety if the scientists and physicians are too afraid to come over when deadly mistakes are made? And far too many mistakes are made. Inadequately tested metal-on-metal hip replacements cause crippling disability, defective cardiac defibrillators, unclean syringes containing deadly bacteria, old-fashioned pediatric feeding tubes cause fatalities because they lacked a well-known, inexpensive safeguard. And these are just the medical devices that the FDA allowed on the market, not to mention the food and drug approval disasters. And if the FDA isn't doing its job and lives are at risk, we have to ask why. The FDA whistleblowers warned us that corners were being cut and scientists were being overruled by the bureaucrats. We need whistleblowers. However, it is worth noting that throughout Mr. Harris's testimony, there was no acknowledgement of the public interest in protecting whistleblowers, only of employee protections. Yet it is well known that whistleblowers save lives and taxpayer dollars and are among the best partners in crime fighting. Congress protected public whistleblowing so that waste, fraud, and abuse and threats to public health and safety would be known. As Senator Grassley said, you couldn't do the majority of the oversight this body does without whistleblowers and without the media. But the FDA policies do nothing to encourage or safeguard public whistleblowing, which is protected so long as the disclosure of information is not prohibited under law. They claim to exclude from surveillance in their interim policy the targeting of disclosures to Congress, the OSC, and others, but this is not enough. A legal review at the front end will not prevent legal public whistleblowing collected through spying from falling into the hands of those in a position to retaliate. Clearly, the FDA and other agencies will not get this right on their own. Congress and the President must mandate a government-wide policy to prevent future surveillance abuses. Of course, interfering with communications to Congress and retaliating for whistleblowing is already against the law, and there are some protections for the identities of whistleblowers in other laws, but Congress should consider specifically protecting the identity of a whistleblower in any surveillance that is done by an agency. Today, we don't nearly know enough about the scope of surveillance across the government. I encourage you to order a report, a study looking at this issue. I encourage you to conduct oversight over other concerns with national security and insider threat programs that might threaten whistleblowers. But importantly, we must not forget what brought us here today, which is the FDA whistleblowers. They were concerned about the device approval process they believed might put lives at risk. FDA officials should not be held accountable for approving, they should be held accountable for approving ineffective and unsafe products, and flawed devices must be taken off the market. There must be more transparency and less deference to the demands for confidentiality by drug and device companies. Seriously, I wonder how much time and taxpayer dollars is spent protecting so-called confidential commercial information. Finally, please do all you can to ensure that FDA managers are held accountable for any violations of the rights of the scientists and physicians who sought to make medical devices more safe and more effective. Thank you.
Thank you. Mr. Harris, a couple of questions. First of all, I mentioned you'd be the person that would review a request to spy on an employee in the future. You'd be the first point of contact. Is that correct? Okay. And your degree is in business administration?
Can you repeat the question?
You have an MBA?
Yes, sir, I do.
You're not a lawyer?
I'm not.
And the person that you, once you decided to do it, that you'd go to would be the same person, the general counsel, who approved this spying in the past. Is that correct?
Well, I want to give the committee, accurate information. So most of what we speak about today predates my tenure at FDA.
No, I understand. I'm just looking at the process. The process in place, the so-called protection that the agency has put forward is you'd still go to the same general counsel. The first lawyer, if you will, would be the lawyer who thought this was just fine before, which was the general counsel. And second of all, before that, you'd go to the chief operating officer, who is, by definition, probably not an attorney.
That's right.
Okay. I just want to understand the system, because I don't approve of it.
So I'll give you the process. So we have a process that requires a request to be formally written.
No, I apologize, but I only have 3 minutes and 55 seconds, and to be honest, the process sucks. So now, let's move on. Ms. Canterbury, you said it very well. They had suspected a criminal activity. Is that correct?
They suspected that confidential information
Right, and so alleging
was disclosed.
Right, so alleging a criminal activity, they did not go to the IG, they did not go to the criminal investigation units, of which there are a multitude within. HHS has their own, obviously the FBI. Let me ask a question, Mr. Harris. Your opening statement, you used some very carefully toned words, and I picked up on just a couple of them as another non-lawyer with business degree. You said that you didn't target, or use a term like that, of members of Congress and all these, but you didn't protect. In other words, not you, but the General Counsel received all of the information without any attempt to screen out, Mr. Van Hollen or my committees or Senator Grassley's committees, or for that matter, lawyers, doctors, and so on. There was no protection in place.
Again, Mr. Chairman, that predates my time at FDA.
Right, but I just want to make sure that's correct, that there was no protection put in place. So the idea that you didn't target doesn't really matter. You didn't protect the likelihood of 5 known whistleblowers, and especially Dr. Smith, a known whistleblower. Your likelihood is he's still talking to members of Congress. He didn't change his opinion that the FDA had problems. So by definition, the FDA knowingly intercepted correspondence with members of Congress because there was a reasonable expectation that he was having correspondence with members of Congress. Let me just ask a couple quick more questions. To your knowledge, you weren't there at the time, there were 5 people targeted. Was there anybody else at the FDA that had access to the information that was leaked to the New York Times? Anyone else?
Again, that predates my time at FDA.
Well, why don't we make the assumption that there were just a load of them, that these 5 people were by all reasonable account not the only ones that had the ability to have gotten this information. Since you received none, the real question is, did the FDA and does the FDA have not the ability to be narrow, but the ability to be broad? If you have a leak and 4,000 people could have leaked it, the only way to do it properly would be to make the assumption that you had to equally monitor 4,000 unless you had a specific, credible reason to believe that one person had done it. Isn't that right? You're the approving officer. I need to understand how you would do it.
In the current process, we would ask for a written request. That request would then be reviewed by a committee before we make any actions happen. From the committee, it goes to a legal review, and we get the legal. You're
the final approval.
And then
would you have targeted just these 5 known whistleblowers, or would you have had to target more people who had access to that information?
It depends on the scenario.
Okay, so you're not binding yourself to any kind of protection for the Federal workforce from being targeted.
Well, just the opposite, Chairman. We clearly state in all documents these days, since our new policy has been implemented, that we consider interactions with the Hill, legal counsel, the OMB, et cetera, as protected activities. When our staff has any interaction with that type of information, they know to
Oh, your staff?
Any staff.
Oh, no, but the whole point is, who gets to see this information under your current policy?
Under the current policy, the information comes immediately back to me. I then bring the appropriate folks to the table, and we talk through our next steps.
And
there's no further.
Okay, so you're looking at correspondence that they had with me,
no,
and you're going to protect me.
No, what I'm doing is actually when they walk up on that type of information,
Who's they?
They cease. Those who are actually
who are they?
Staff members who are part of the process.
Okay, I just want to understand. You got staff members looking at correspondence with members of Congress.
No, sir.
No, you just said that.
That was not my statement. My statement was when we are going through the monitoring process, should my staff, who is actually administering the monitoring process, find information of that type, is considered protective activity.
But they see it in order to consider it.
Stop. Well, during the monitoring process, they may walk up on that, but they stop all processes today. I can't tell you what happened 2 or 3 years ago, but I can tell you what happens today.
Okay. Well, let me just have it close by saying, do you know the name Paul Hardy?
I do.
Do you know what happens if you Google his name?
No, sir. What happens?
Well, he Googled his name because he was concerned and apparently looking for a job, feeling that his was insecure.
Oh, I'm sorry. I thought you said Paul Harvey.
No, Hardy.
Oh, no, I don't know Paul Hardy.
Well, he was one of the targets, and the Internet was filled and Googleable with all those screenshots, basically, because your agency took no precautions on that confidential information. His correspondence with Congress, if it was there, his correspondence with his doctor, his lawyer, his priest, anybody. And it simply became an Internet phenomenon that you could Google and get it because it was put out on an open site because the FDA did not take the precautions, did not fill out the forms properly, and did not protect that information which it had captured clandestinely. Isn't that true?
Well, that may have been the case a few years ago, but
No, wait a second. You're a witness. You're under oath.
I am, sir.
You say may have been the case. Are you here today and you don't know if it was the case?
I was not there 2 years ago, so I would not have.
Do any of you know if it was the case or if I'm just coming up with something that's Internet lore?
Respectfully, sir, I believe that Dr. Shuren was in charge at CDRH at the time.
Are you familiar with the, and I'm just on the same thing, I've got to give time to the ranking member, but are you familiar with the release of that information, the fact that it wasn't protected and it became essentially Internet public?
Yes, I know information was made public. I don't know the full extent of it. I wasn't involved in dealing with the contract or any handling of that material. But I am aware that information was posted on the Internet.
Okay. And I'll give you equal time, but if I had your indulgence for one more quick question. There's been an alluding to the confidential information the New York Times got. Just for the record, it wasn't patent information. It wasn't a deep, dark secret on how you make a product. It was the fact the product was in question as to whether it was safe and effective. Isn't that correct, Doctor?
It was whether or not the product was under review, and that has been considered confidential. Companies many times do not want competitors to know that they're working on a product and that it's under review by the agency.
Okay, I just want to understand the level of trade secret is a product the New York Times reported was under review and may not have been safe.
It was just simply that the product was under review would be confidential commercial information.
Okay, but it's something that I want everyone to understand that the term confidential is not the term the public thinks is all that confidential. Most people look at these products, clinical trials, the process of approval, and then the question of whether they're being re-reviewed. Most people probably listening and watching today believe the public has a right to know that information and may not agree with the FDA's view that that is private or confidential or somehow a secret from the American people as to whether a product they may or may not yet be on the market is safe and effective. Ms. Canterbury, if you wanted to respond quickly.
I couldn't agree more. I think that at the base of all of these questions is, why is this information considered confidential in the first place, and is that serving the public health and safety? I think that there needs to be a question answered about why the FDA did not choose to first verify whether or not it was legitimately considered to be confidential in the first place and investigate that matter instead of investigating a so-called leak of confidential information.
Thank you. Mr. Cummings.
If I may, I was going to respond to your question.
Of course.
But our employees know that that information is confidential, and that has been for a long-standing time. Keeping that information confidential is critically important. It can undermine ongoing review of medical device applications. In fact, I believe in that particular case, it in fact did that. It undermines our medical device program, keeping that confidential information confidential. Companies, that information we need for making decisions about products, and companies rely on the fact that we protect that information. We don't protect it. The companies don't bring innovative technologies to the U.S. Our patients lose. Public health gets hurt when that happens. That's why those protections are in place in the first place. That's why Congress put the protections in place.
Doctor,
and it hurts American
I
businesses.
appreciate what you're saying. They bring innovative products here because of profit. But let's understand one thing. Do these companies sign a gag order? Are they prohibited from disclosing that you're looking at it?
No, they may disclose it. That is their decision to make.
Okay, thank you. So it's a one-way gag order. Please, Mr. Cummings.
Thank you very much, Mr. Chairman. I want to pick up where the Chairman left off. Dr. Shuren, prior to the initiation of the monitoring, the agency believed that the FDA employees were involved in unauthorized disclosures of confidential information and trade secrets as a result of the monitoring. What did the agency find?
So the agency did find, as I understand, that there was unauthorized disclosures to members of the public, and that is, from our perspective, in violation of HHS personnel policy and probably a violation of the law.
So the agency found clear evidence that Dr. Smith and the other FDA employees whose computers were monitored were involved in unauthorized disclosures of confidential agency information. And as I understand, it, that's a violation of the law and can be subject to criminal penalties. Is that correct?
Depending upon the kind of information that's released, but yes, this can be violative of the law.
Now, when I listened to Ms. Canterbury, and I'm going to come back to you in a moment, Ms. Canterbury, but there were, you know, one of the things that she said was perhaps the FBI and other agencies should be handling these kinds of issues. And I'm trying to figure out how it would, and you can address this in a minute. I mean, you all have laws that we passed that you're trying to adhere to. And so I guess there's almost there is a duty to at least look into it. Is that right?
There is an obligation to look into it.
And if you don't look into it, then you're in trouble. Is that right?
That's correct.
And as I understand it, with regard to the New York Times, there were people who were companies that were complaining that, look, you know, we gave you information. We expected it not to read about it in the Times. That's the last place we expected it to be. We thought it was confidential, and now this is where we see it. Is that fair to say?
That's correct. Actually, the company involved sent a complaint and actually pointed out that we were in violation of federal law. They asked for an internal investigation. 5 days after receipt of that letter is when monitoring was started. It was also in the setting of a pattern of unauthorized disclosures that had occurred starting over a year before.
Now, I don't know whether you need to hear this question too, Mr. Harris. I don't know whether you heard me a little bit earlier, but it seems that there is a major issue here with regard to whether this investigation should have been just retrospective or retrospective and prospective. And I'm just wondering, what's your view on that?
So the honest answer is, I don't know. I'm not an IT expert. And when the issue was raised, what we asked for, when I asked my executive officer for, was options to try to identify the source of the leak and to address further unauthorized disclosures. Our information technology people decided on what the appropriate solution would be. So I do not have the expertise.
So you just pass it on. Look, you say we got to, obviously the New York Times has got information that they're not supposed to have. I just want you to help me figure out how this information is getting out there. Is that one of the things you wanted to know? Yes,
what the source of the leak was, what the options were for doing it, and they proceeded to authorize.
And what was your plan after you got this information? I mean, what happened?
Yeah, so what happened with the information, we put a process in place, also try to protect privacy. This went, first the IT people collected information they thought met very narrow search terms. That information was then put on secure iron keys, one of two. It was passed to my executive officer. It was then conveyed to a subject matter expert to look at, was there confidential information in here? And then if there were issues of concern, there was something I called the management team. There was a group set up, which was the Assistant Commissioner for Management. It was lawyers from HHS and employment law, and it was people from our labor-employee relations, a group already established actually as in part as a protection for these complainants. And that information then went up to these individuals and others to try to decide what, if there is an issue here, what are the appropriate steps to take, which could be administrative or could be referred on for other action.
And do you know which specific medical devices these individuals were concerned about?
I know of some that were reported out in the press and some that went on a referral up to the OIG. And I say that because I wasn't a subject matter expert. And I'm not the person who makes the personnel decision, so I was not reviewing the emails. We were trying to limit the people who would look at any information coming out in order to respect privacy of the individuals.
Now, have these employees' safety concerns been borne out? So you don't know that either?
Well,
in your assessment, were their concerns valid?
Well, for the products, and I'm aware of the concerns that they were raising on a variety of products, and I don't think that they're concerns were valid. I'll raise the case in question here of the New York Times article of CT colonography, which was to be used to screen asymptomatic patients for cancer. And there was a lot of good evidence on the table, several clinical studies, a big one that was funded by the Federal Government. And just last year, we held a joint meeting of 2 advisory committees at the FDA, experts in radiology and gastroenterology, 20 people in all, and they unanimously felt that CT colonography should remain an option for the screening of asymptomatic patients.
Well, it's interesting that the employees raised concerns regarding integrity of the device review process, and they called it corrupted and distorted. Did you know that?
Yes.
And when you first took over the center, did you evaluate these concerns regarding the review process?
I did look into the concerns from my own standpoint of the complainants. The Office of the Inspector General was also investigating whether or not managers were retaliating against these complainants. And I will tell you, the OIG found that there was no retaliation. There was no prohibited personnel practices. The complainants raised concerns about that investigation. They reopened it, and then they subsequently concluded again there had been no retaliation. And I will tell you, I also took steps along the way for trying to assure that these complainants were actually protected, and to make sure that if there really were problems, and if I thought there were problems, I would have done something about it.
And so you're telling us today under sworn testimony that you are concerned about whistleblowers and would do everything in your power to protect them?
Yes, I would. One example of something that I did do soon after I got there, I was hearing concerns from them. I was looking into the managers. I did not see problems. But I said to them, look, you're complaining about the managers all the way up your chain of command to the office director. Here's what I will do. I have 2 offices involved in pre-market review. I will offer to move the entire radiological devices branch out of the one office and move it to a new office with new managers. I didn't have evidence that I had bad managers. The OIG was continuing its investigation, but I said, in light of that, if the OIG finds problems, we will pursue that. But I'm willing to do this. I'm willing to disrupt my organization because of your concerns, and I did that. They wanted the move. I made the move, and within a few weeks of the move, the exact same complaints were now being levied against a brand new group of managers.
Ms. Canterbury, you heard Mr. Harris, and he talked about the IG report. I guess that's what he was saying. And the recommendations,
yes, sir,
have now, you're telling us, Mr. Harris, that all of those recommendations are now in place?
Yes, they are.
And when did they go in place?
September of last year.
September of last year. So with regard to the recommendations, you all didn't know about them in September, did you?
No.
I mean, we just got the report last night.
Correct.
So how did that come about? Just out of curiosity.
Again, it goes back to, I documented a couple of notes, and Ms. Canterbury's statements about making sure we protect all employees and their rights, she's right on the money. So our process does that. I got a little bit concerned with the chairman's comment that the process may suck. So the reason we're here is because they were not commonly understood across the agency. So what we put in place today are commonly understood processes where a request comes in, it's formally documented, then goes for a committee, and then goes for legal review and approval. Even beyond that, if we approve a process for monitoring to begin, there are regular checkpoints along the way to make sure we know what's going on there. So we weren't aware of the IG's report, but we could have taken this in a Keystone Cop approach and then find ourselves here on a regular basis. We decided to look at a more methodical approach of this, and knowing that there are many scenarios out there that we have to consider when putting any policy like this in play. What I want to be able to have us do is have the folks who operate within the administrative process when it comes to monitoring understand the processes first. Then we permeate the organization so they can understand what procedures we go through.
Ms. Canterbury, just my last question. You heard about, you have your concerns. You heard Mr. Shuren say that he's very concerned. It sounds like Mr. Harris is very concerned and have taken steps to address the issue. Do you believe that it's been adequately addressed?
Thank you, sir. I believe that they are taking steps. I don't believe it's been adequately addressed. I would very much like to hear how he intends to protect the public whistleblowing once he receives, as COO, what has been collected, and there is no legal review of the collected information guaranteed under the interim rules. and I would like to hear from him on that. I also think it's curious that Dr. Shuren says that he sought to protect those particular whistleblowers who were targeted for surveillance, if that's his idea of protection. I find that very curious. I also want to point out that it doesn't matter if the whistleblower's concerns bear out to be valid, whether those devices are unsafe or effective. As you know, sir, it is a reasonable belief that is protected under law for whistleblowing. And I also wanted to just point out another curious thing that Dr. Shuren said, which was the surveillance began 5 days after the receipt of a letter from GE Healthcare. In fact, the letter is dated April 16th. They received the letter on April 21st, and the surveillance began on April 22nd, according to documents that we have through FOIA and through the IG report and through the staff committee report. So I have never in my life, sir, seen the federal government move that fast. I find it highly suspect that the letter arrived and then they made the decision after the arrival of the letter to do this surveillance.
Well, Ms. Canterbury, as my time has run out, this is what this is all about, trying to make sure that the federal government is doing the right thing. But I want to keep in mind what Mr. Shuren did say. He's saying he's got a set of laws that we passed, and he's trying to adhere to the laws that we passed. And so there's certain things that they had to do. Question is, did they do it right? I don't think so. But it sounds like they're going in the right direction. Unfortunately, I've run out of time. I wish Mr. Harris could answer your question, but I've run out of time, and I'll yield back.
Thank you very much, Mr. Cummings. We'll now recognize the gentleman from Michigan for 5 minutes.
Thank you, Mr. Chairman, and thanks to the witnesses for being here today. Dr. Shuren, I'll give you a chance to respond to the timeline that Ms. Canterbury addressed here. It appears the differences in the dates of beginning the investigation, sending the letters. Respond to that, if you would, please.
Oh, yes. No, in terms of when we received it was closed. My only point was still within 5 days of getting the receipt of that letter, the monitoring started, namely to say that this was not disconnected in time, that this was related to this complaint that came in, as well as a series of unauthorized complaints. That was my only point to make.
Ms. Canterbury, let me ask you some questions, and then you might respond to that with greater detail as well. Is there any situation where monitoring employee communications with Congress or OSC can be justified?
No.
It's a simple answer. Then, is the problem of monitoring protected employee communications widespread across the federal agencies?
I don't know.
Federal agencies.
Yeah, I don't know the answer to that, and I don't know that anyone does. I think that it would be very good for this committee to order a study, a comprehensive independent study, perhaps at GAO, perhaps in consultation with the MSPB, to determine the extent to which agencies are using surveillance programs on their employees.
So this could be widespread?
It very well could be, and there could be widespread abuses.
What protections can agencies put in place to minimize the monitoring of protected communications, such as with Congress or OSC?
Well, firstly, I think that we need to question whether or not there's a legitimate reason for agencies to use surveillance on questions of criminal behavior or leaks of potentially unlawfully disclosed information. I think that, again, law enforcement should be conducting those investigations. And if there is a few legitimate, very narrow reasons to monitor employees in this way, can it be done in a way that is in balance with the rights, the constitutional rights, with whistleblower protections? And if not, perhaps good old-fashioned management is in order.
Well, should management, and speaking of that, management be responsed to make sure that the law enforcement agencies are aware of their concerns, potential concerns? Is that what you would suggest?
Yes, there would be a referral to a law enforcement
agency. So quickly step
agency.
away, refer it to a law enforcement agency.
Yes.
Mr. Harris, tell me about training that's being implemented since you've arrived, the directions that are going to management relative to leaks, relative to whistleblowers and how you deal with them, relative to responding to what we just discussed here about referring to an appropriate agency to deal with the law and not outside of the law.
So can you give me your first question again?
First question is, what are you doing? What training have you implemented?
Got it.
Secondly, what administrative steps have you made to make sure that the department, the agency, stays out of it as much as possible to make sure that whistleblowers understand that they're part of the agency, but they're protected by the law, and that there are appropriate agencies that will be brought in to make sure the law is followed?
Yeah, there's standard training that occurs at FTA. There's when an employee comes on board, an orientation, they get understanding about IT security awareness programs and trainings. There is annual training for No Fear, which does address the whistleblower issues. We have regular training that goes on in the information technology groups. And so we have lots of required training every year for all of FDA to understand how security awareness works. We often, as I said earlier, the banner flashes up and makes them aware of their right to a reasonable lack of privacy. It comes up on all devices we give them. As it relates to the management process we put in place, clearly, as I stated earlier, I'd like to address Ms. Canterbury if I could. And I think this will kind of tie it all together.
Tie it together.
We consider the whistleblowers as our staff. They should not be treated any different as it relates to protection. We give everyone protection in our staff. So we don't consider them outsiders. We consider them as part of our staff. The way we want to try to approach the issue is the committee we put together is not just myself and a couple of attorneys. There's an HR director there to determine whether we've infringed on employee rights. There's IT professionals there to give Mr. Shurin in the future better information and guidance. There's the legal team, and then there's myself. When we do find that we've stepped into an area where we have communication occurring between Congress or anybody else, again, they stop everything they're doing. Nothing continues. Monitoring stops. My office is notified.
Are you notified immediately then?
Immediately.
When they come across something, it all stops?
Immediately.
No more eyes are seeing it?
Nothing else happens after that. This is why the committee is such a small group. We then bring legal into the conversation, and if it's appropriate to send it out to another law enforcement agency, we do that.
Well, I appreciate the answer, but I would suggest that last statement would be the approach to take more rapidly to the outside agency. Mr. Chairman, thank you.
Thank you very much. We'll now recognize my distinguished ranking member from the subcommittee on postal census and the workforce, the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. I want to thank all of the witnesses for your willingness to testify and to help the committee with its work. I do want to say that from an oversight and government reform perspective from this committee, our goal is to create and maintain an environment where whistleblowers can come forward. As has been said by Ms. Canterbury and the chairman and the ranking member, and Mr. Grassley earlier, our bureaucracies and these agencies and the work that they do has become so complex, whether it's derivatives or whether it's financial derivatives or whether it's the FDA. Some of this is just so complex that unless we have someone on the ground in place that comes forward, our chances of finding out about wrongdoing or misconduct is negligible. So we really need to make sure that we have an environment there where people feel comfortable that if they have a reasonable belief that the laws are being broken, or that the public is being harmed, that they can come forward. So there's a couple of instances. Usually the FDA flies below the radar screen, but this instance really gets me. And it's the second time recently that the FDA has just caused me to shake my head and ask, what the heck is going on over there? This instance, it looks like there's a very robust framework in place to protect manufacturers' trade secrets. And in this case, I'm not so sure anybody has ever pointed to specifically trade secrets that have been protected. But by God, we went after these employees because we thought there might be a chance that they might disclose something. So I think it was very, very strong response in protecting the manufacturers. I think it was very, very weak in terms of protecting the employees. And you know, I have to acknowledge, Mr. Harris, this predates your involvement here, so I'm not criticizing you. The other situation. So I see the FDA overriding their scientists in this case. And the last time that the FDA, their conduct came to the attention of this committee was the approval of Zohydro. Okay, now I know this doesn't involve medical devices, but in that case, the FDA overrode again their own scientific panel. Their scientists voted 11-2 that approving Zohydro, which didn't have any protections against abuse, quite similar to the early iterations of OxyContin. So 13 scientists, 11-2, they said to the bureaucrats, do not approve Zohydro. And the FDA turned right around. With an opioid epidemic in this country from coast to coast. This is one of the most serious threats to our communities. And the FDA goes ahead and puts a gun to the head of the American people by approving Zohydro. So we got this problem. You know, personally, I spent a lot of my time dealing with the effects of substance abuse in my communities. I got 3 cities, major cities, and I got 22 towns, and no one is immune. Good families that are struggling. It's just unbelievable. And so I see it just blows my mind that the FDA would approve Zohydro. And so I need to put you on notice. You have shaken my faith in the FDA because of that decision and what's going on here today. And I just want to put you on notice that, you know, I used to give people the benefit of the doubt, but I've seen such bad decisions coming out of that agency that we got a problem, which is I got a problem, you got a problem. So, you know, we got to start straighten up and fly right and start doing things that are in the best interest of the American people. And, you know, I appreciate that your mission and your goal is to do the right thing. I just think we've strayed. Sometimes the bureaucracy can do that. And we just need to get back on the same page here in protecting the American people. I've exhausted my time, Mr. Chairman. I thank you for the indulgence, and I'll yield back.
We will be happy to have someone provide follow-up to you on this issue.
That would be great. Thank you, Mr. Harris.
And, sir, we would also be happy to talk to you more details on what really was happening with these unauthorized disclosures and the impact. Because, in fact, what it was doing is it was stifling other scientists. It's not that these complainants were necessarily just willy-nilly overrode. There were other scientists in the agency who disagreed with their opinion, and those people's opinion was actually being disenfranchised. People were feeling harassed, retaliated against. Other scientists were feeling retaliated against by the complainants, and they were complaining that the unauthorized disclosures was having a chilling effect on internal discussion within the FDA, and that people were afraid to put their opinions in writing because it would be disclosed to the press. It's the same thing that Senator Grassley talked about. We want to have open discussion within the FDA. We think it is so important, but it goes on both ends. And we were seeing that actually was being adversely affected, and that adversely affects public health. We cannot make well-informed decisions when that happens. And that was a misuse of those disclosures, and that's unfortunate. And they were used to influence public meetings, and they were used to influence advisory committee meetings.
Well, I'd be happy to have that information offline, Dr. Shuren. And again, I thank you for your testimony.
Thank you very much. I'm going to now recognize myself for 5 minutes for a couple of questions. First off, I want to say that whistleblowers are the lifeblood of this committee. It's dedicated government employees who see something going wrong in their agency that have no recourse other than to bring it to the attention of Congress, which is the right way to do it. It's not the right thing to do the way Mr. Snowden did it and take it to another country. And we work hard, and we've passed legislation to make it safe for whistleblowers. And this committee, and I think Ranking Member Cummings will agree with me, will bend over backwards to protect a legitimate whistleblower. In fact, the committee website, oversight.house.gov, has a place you can go online to become a whistleblower. And I guess there might be a lesson in this for potential whistleblowers. Maybe the initial contact needs to be made from your home computer or a computer at the library or from a Starbucks. But you shouldn't be afraid to use your government computer to report government problems. And Mr. Harris, I know a lot of this happened before you got there, but you are the acting chief information officer. So I want to take a step back and maybe look at what should have been done. I mean, I understand the our computer, our rule mentality. In the private sector, you've got a lot more flexibility than you do in the public sector. The Constitution doesn't apply you due process in your private sector job. In many private sectors, there are no whistleblower statutes other than potentially to the government. So you got a lot more, as a manager, you got a lot more options in the private sector. But in the public sector, going in and installing snooping software seems rather draconian. I would think good practice is to have something on your network that captures all incoming and outgoing mail, and then you have the ability to search that after the fact if you've got a leak. And I'm going to talk in real, I've used Encase before. That's a forensic software that lets you go copy somebody's computer. But nowadays, with all compliance issues in various industries, there are appliances that you can put on your network that catches all the mail and saves it. And you ought to be able to search that for emails to the New York Times and have an exclusion saying, if it's mail.house.gov, don't show me that. I mean, it seems like it's that simple. Didn't you all hire a contractor back there? Couldn't you have told the contractor when pulling the Encase stuff, if it says mail.house.gov, I don't want to see it?
Yeah, I think you're on the right track. I think one thing we should note is that monitoring is actually rare. And I think what sews this together is when you think about the reasons we do monitor it at times, I can give you a couple of instances. I mean, we have had cases of child pornography. In my mind, we should immediately act on that. And we should immediately start to look for the issues there because the child's life is in the balance here. And then there are other instances where insider trading does become an issue to protect trade secrets. But, everyone is correct. The need to protect those who whistleblow is important. So this new process that we have in place does that. It has, again, on the committee, a legal individual, someone from IT, someone from HR to consider the entire range of issues that we may face before we even initiate a monitoring process.
It's just hard to judge what the culture of that is. If within your agency there's a culture of gossip, does it slip out? You've got to deal with the human elements of that as well, and I do think there needs to be a technological solution to that. Let me go to Ms. Canterbury and get her thoughts on what the appropriate way to do this is.
So first I'd like to ask why on earth the FDA would conduct surveillance if they had suspected child pornography or insider trading occurring. Why would they not go to the FBI? That just makes no sense to me. So I'm struggling with under what circumstances.
You run into. I've run a computer consulting company. I've done this for private sector. You've got an employee you think is. Let's take child pornography out of it and is just surfing porn, and that's against your policy. They haven't broken the law, but they've broken your policy. So I mean, obviously there are cases where you need to do that.
Sure. And so in that case, my question would be, on the back end of the review committee, I think is a substantial structural reform, but it's only reviewing, to my knowledge, according to your interim policy on the front end. So would be an improvement would be to do a similar review on the back end, because there's no way you can use enough search terms to protect public whistleblowing. So if an employee is blowing the whistle with non-legally protected information to the New York Times or to the Project on Government Oversight, that also cannot be swept up, or they've been in violation of the Whistleblower Protection Act.
And I'm going to agree with you that in many cases retrospective is the way to go. I'm about out of time, but I will give Mr. Harris an opportunity to respond before we go to the gentlelady from California.
Let me be clear. We by no stretch of the imagination are coming here today to tell you that our process is 100% perfect. The idea behind this is to have a methodical approach to this. And by the way, the FBI come to us sometimes for referrals to do some of the work that we do. And so it is by nowhere near perfect, but the only way the agency can move forward is to start something now, and then we perfect it to a point where we can then spread it to the rest of the agency, and then we all understand what our policies, rules of engagement are around monitoring.
All right, thank you very much. I appreciate your indulgence. We now recognize the gentlelady from California.
Mr. Chairman, thank you, and thank you to all of our witnesses. You know, we are really very good here at calling agencies onto the carpet and beating them up, and then talking to the companies in our district and hearing their complaints about the process being too slow, and the result is that so much innovation is going abroad because our process doesn't work. We can't have it both ways. If we want the FDA to be more streamlined, so more of this research and development, clinical trials happens here in the United States, you know, we've got to embrace that. If we don't, then we should just tell all of our constituents that if they want the new medical device that can save their lives, you're going to have to go to France or Germany to get it. Having said that, I want to send some kudos to Dr. Shuren, because we do beat you guys up from time to time. I'm sitting on an airplane 2 weeks ago, coming back from going home, and the gentleman sitting next to me is a VC who specializes in medical devices, and he had nothing but praise to offer about your good work, Dr. Shuren. So I wanted you to have that at the outset. Now let's go to my questions. It appears that there were search terms that were developed within the administration that were superimposed on the computers of these scientists. What were those search terms? The Inspector General report isn't very specific about them.
The search terms were K followed by a string of letters,
right,
which indicates an identification for a 510K submission, the word colonography based on the release in the article in the New York Times. And then there were also names identified of individuals where managers had voiced concerns in the management team that Dr. Shuren talked about that were performing ghostwriting.
Okay, so the first two make some sense to me. The others appear to be the beginnings of a witch hunt. And that troubles me. I think that Ms. Canterbury's concern is one that we all have, in that if we want to be clear about not having reprisals, it's better to have a hands-off investigation or review taking place so that it's not within the department. Go to the Justice Department, whether it's child pornography or leaks of trade secrets. And it's not your core competency anyway. So I guess the real overriding question that I have is, why not just punt these all to justice for them to undertake the review? Dr. Shuren?
Yeah, so a challenge we faced back then is, in the past, we had our Office of Internal Affairs. That is the group who did investigations within the FDA. And due to concerns raised by Senator Grassley, and I understand those concerns, in early 2010, the policy changed. The commissioner said, in the future, the Office of Internal Affairs cannot do investigations of allegations of criminal conduct for employees who made allegations against the agency. It would go to the Office of the Inspector General. But they were not doing investigations unless they had adequate evidence to do it. And that has caught us in a bind. And in fact, when just the GE letter was sent to them, they came back and said, at this time, based on the information provided, they're not taking any action. The referral lacks any evidence of criminal conduct. But after, from the monitoring, there was evidence of unauthorized disclosures. In fact, the OIG did open a formal investigation and did look into it. And at that point, they decided, we're not going to prosecute. But they also came back and didn't say that this wasn't wrong. In fact, they said, we understand you have sufficient evidence to support administrative actions, and they closed the case at that point. In other words, this could be a problem. You are welcome to pursue it now with administrative action, and that's what happened.
All right. I have very little time left, but I'm concerned about the allegations by the scientists that thought that these devices were potentially unsafe or exposed people to radiation. Where are we in terms of evaluating that?
Yeah, so for CT colonography and their concerns about exposure to radiation, it shouldn't be on the market. As I mentioned, there's a lot of evidence to support it. We think it is safe and effective. And last year, there was a meeting of joint advisory committees. So 2 advisory committees with experts in radiology and gastroenterology, 20 people. And they unanimously felt that CT colonography should be an option for doctors and patients for screening asymptomatic individuals for colon cancer. Unanimous. Time and time again, there were issues that were brought to advisory committees, outside experts, who did not agree with the complainants. In one case, I actually set up for an issue to be brought to the advisory committee, and I let the complainants give their own individual perspective. I actually had 2 perspectives. We never do that. We have the center provide one perspective. And here I said, there's difference of opinion. I want to put sunshine on it. Didn't hide from it. Put sunshine on it and get feedback. And the advisory committee didn't agree with the complainants. And scientists within the agency, there were many scientists who didn't agree. And in many of our managers, they are scientists. I mean, these people are also experts, and they disagree. And that's okay. People can disagree. They should disagree if they feel that way, and we have a process, if they disagree, how they can appeal that. Unfortunately, never took advantage of that process, which actually brings it all the way up to my office, can even bring it up to the Commissioner's office. And it has to be in writing, and they have to justify their rationale, and never took advantage. Instead, it was put information that by law is prohibited to be disclosed by any FDA employee, whistleblower or not, and put that out in the public venue. And that does adversely affect public health. It adversely affected discussion within the agency. It adversely affected the very issue of open dialogue, which they were complaining about. In fact, in one investigation, independent investigation, was found that it was one of the complainants who was creating the hostile work environment.
I thank you. My time's expired.
Thank you. At this point, I'll recognize myself. I'd like to thank each of our panelists for being here today. And Mr.
Yeah, I just want to close.
Okay, well, I'm going to ask it.
Oh, no, sure.
Yeah, briefly. But, Doctor, you've answered a few of my questions. But after listening to testimony and the questions that were asked, I seem to have all my questions answered. But there seems to be an underlying problem that you just addressed, is that, when you have a whistleblower, there's procedures to follow to make your points, to make your complaint heard, correct? And you've just explained that procedure. But there's, according to your testimony, if I understood this correctly, they didn't follow all the procedures and went over and above and then contacted Congress or blew the whistle, so to speak.
No, they are welcome to contact Congress. The issue was they disclosed confidential information that's prohibited by law from disclosure to members of the public, including the press. It's never about Congress. None of this had anything to do about Congress. They'd been complaining to Congress for 18 months before this started. When I first started at the center was in September 2009. Before I could even speak to any of my staff and hold an all-hands, my first 2 days I spent a lot of it on Capitol Hill at the request of congressional staff to talk about them and their complaints. They were complaining all the time, which is fine. No one objected. And I kept hearing they were constantly complaining. If anyone was going to retaliate, they would have done that well before. This was in response to unauthorized disclosures, and the OIG even concluded that there was reasonable concern for doing the monitoring. Now, people will have issues about how that was done, but that's a different issue. This was nothing to do with retaliation. There was no targeting of Congress. The OIG concluded that as well. There was no targeted of protection disclosures by whistleblowers. None of that.
Thank you, Doctor. Ms. Canterbury?
So the Inspector General did not confirm that there were disclosures of unauthorized information. The staff report, the ISA Grassley report, explicitly says that they did not find evidence of unauthorized disclosures in their surveillance of the employees, of the whistleblowers. And I wanted to go back to one other thing that Dr. Shuren said about the IG refusing to conduct an investigation for lack of evidence. The IG declined on May 18th in 2010 to investigate for lack of evidence of criminal activity, but also pointed out to the agency at that time that 5 U.S.C. Section 1213 identifies the disclosures, such as the ones alleged when they relate to matters of public health, public safety, may be made to the media and Congress. To the media and Congress, as long as the material released is not specifically prohibited by law or protected by executive order classification. So that's what they got back, was their first determination, their first warning not to violate whistleblower protections. When they went back to the IG and asked for a review, the IG looked at whether or not these unauthorized disclosures were in violation of the law, consulted with the Department of Justice, and in fact found that no further action would be taken. DOJ declined to prosecute. The OIG declined to investigate it further. There was no evidence of prohibitions of law. And what the IG said in the letter was not that there was sufficient information to take administrative action, but instead it said your office indicated it had developed sufficient evidence to address the misconduct through administrative process. So the message from the IG was not that we think you have sufficient evidence, but you say you do, so go ahead and take care of it administratively.
Thank you. Yes, but the OIG in the first place was actually making clear you can have certain disclosures to the media unless it's prohibited by law. That was the whole point. The kinds of disclosures that were occurring and the ones we were concerned about.
I think what really concerns me is that when an employee, a scientist, raises a red flag on some medical equipment or medical product, and they bring it to the attention of the people in charge of the agency. And yet, for some reason, their issues aren't addressed to their satisfaction. They have to go outside of the agency to get redress. I think, to me, after listening to all this testimony, it seems to be a cultural problem within a lot of government agencies, not just the FDA. So I think that's the thing we really need to focus on. Why can't an employee, a scientist, probably one of the smartest people in that agency, have some concerns, and those concerns be addressed in-house and taken care of? And yet, even if you have to put in some overtime.
I would agree with you, and actually—
But apparently those aren't there. You have not created a culture, or the FDA has not created a culture where those things can be addressed and the public can be satisfied. And I think I'm out of time. Now, Mr. Cummings? Thank you.
Thank you very much, Mr. Chairman. Looking at the report of the IG, Mr. Harris and Mr. Shuren, it says, and it's on page 21 of the report, it says, given the FDA's interim policy addresses our 5 recommendations outlined above, HHS should determine whether all other individual op-div policies meet our recommendations above. HHS also should regularly review and, as necessary, update its department-wide monitoring policies to ensure they are compatible with new and emerging technologies and methodologies. Information technology is continually changing, and a static monitoring policy could fail to address key implementation issues as capabilities evolve. And I just want to make sure, it sounds like the IG is satisfied for the moment But as he says, the technology is continuously changing. And as you know, you can have technology today that's outdated today. And so the question becomes, you know, I want to, what I'm going to do, Mr. Chairman, and with Chairman Issa, is try to follow up with the IG to make sure that he is satisfied that everything that can be done at this moment, consistent with his recommendations, has been done. And number two, I'm just curious as to how you plan to keep up with the technology and make the changes that are necessary so that we're not outdated.
Thank you, sir. Clearly, as we stated earlier, we don't consider this process as anywhere near completed. Instead of static, it has to be fluid. We have to keep up with the emerging technologies. I mean, there's a smart kid somewhere who's able to come up with an idea of how to even breach our system. So we have to always be out in front of the process. But going back to the earlier statement that we know that we need to have a set of clearly understood processes across FDA that requires us to have, again, approval before anything starts. I think the IG is also stating that we've started out pretty good, but we still have much more work to do. We recognize that. The agency recognizes it. So we're by no way saying that we're done here. We have a lot of work to do.
I know the Chairman was about to end the hearing, but I'll just finish my closing right here. Yeah, I know. I saw him. That's why I said was about to. But I just want to thank all of you for being here. And I want to reiterate the comments of Congresswoman Spear and also Lynch. It is so important that government operates correctly. Because when government does not operate correctly, there are consequences. I go to the same bank every Friday. And for the last 5 months, I've been following my teller whose son's wife his girlfriend was having twins. And so, you know, everybody's excited and everything. And then about a week ago, I went in and I said, well, you know, she was so excited that these twins were going to be born, and they knew it was 2 boys, and I was excited for her, and I would ask about them every time I walked in the bank. And then she said, they've been born, and she said, I got good news and bad news. She said, the boys are fine. The mother's in a coma. And apparently there was some complications, developed MRSA in the hospital. And then when I came back last Friday, she said she died. Whether this was with regard to a device, I don't know. I'm not saying it is. But now we've got 2 boys, a week old, who will go for the rest of their life without their mother. Those are the consequences. And I think a lot of times we here in government forget that there are people that are affected by our decisions, but they are. And so I think first of all, I don't think, to be frank with you, the whistleblower has a right to remain silent if they see something wrong. That's why we want to protect them. We want to get it right. And I'm asking you all, when you go back to your shops, to reiterate that we're going to continue to follow this. I know the Chairman will and our committee will. But this is so very, very, very important. And I heard you, Ms. Canterbury, and basically what you were saying was, look, you know, we don't trust that this is going to work out. It's not all complete and all that. Well, it's got to work out. It has to work out because the American people deserve absolutely nothing less. That's why they pay our servants, our federal servants, employees, to do these jobs. And going back to something Chairman Issa said, it's also about trust. So the more we do it right, like you said, Mr. Chairman, when you were talking about dismissing everybody, however, you know, when you said, you know, trying to make sure that the whistleblowers were protected, those are the kind of things we have to continue to do because the public needs to feel that trust, and we have got to make sure that we take care of them. And so I'm going to thank you very much. I'm out of town, Ms. Canterbury, but that's up to the Chairman. Good.
I just wanted to say that I have full trust that if you and the chairman work together, that you will get the job done right.
Thank you very much, and we will.
Thank you. At this time, I'd like to recognize the gentleman from Florida, Mr. Micah.
Well, thank you, Mr. Chairman and Ranking Member. I came in a little bit late, and I'll try to ask a couple of questions. Hopefully, they haven't been asked. I was going to turn my first question to Mr. Harris. And Mr. Harris, in September, I guess, of last year, you were acting CIO, and you released an interim policy staff manual and guide for employees' computer monitoring. You have both the role, I guess, of, is it COO and also CIO?
Yes, sir.
Okay. And now in that capacity and in developing that manual, under the interim policies, what are your responsibility as both COO and also as the Chief Information Officer?
As the COO, it is my responsibility to make sure that the process is fluid and that it is commonly understood by all. As the Chief Information Officer, it is to make sure that we give good guidance to program offices and centers across FDA when they have a request to look at issues that may occur within their centers. And so there's two separate hats there. One is of processes. I mean, this is not about power. This is really about well-matured processes that the entire agency can understand what we're doing from A to Z. And from an IT perspective, Dr. Shuren spoke on it earlier, the question was asked whether we could have taken a different approach. I think as an IT professional, I would have said that we need to look at the entire scenario so we can determine the most appropriate approach.
Well, do you think, again, with your in the position of being both a COO and CIO, there's a potential conflict? Some of your responsibilities are for the approval of the monitoring, the execution of the monitoring, and the direction, but also the review of the monitoring. Do you see that as something that actually should be kept separated? Are you able, I don't know how you're able to achieve your sort of I would see it as in competing roles. What's your opinion?
Well, the review committee that we have as part of our steps does have legal review included in it. So it is, when it comes to it as a formal request, there's a committee, again, that has an HR person on it, has an IT person, a legal person on it, and then it comes back to me. So they have an opportunity to look at it without me even being present. But I think the most important part of this is the legal review takes place. And then before anything starts...
So you're saying on top of this there is another review that would ensure, again, some objective review?
Yes.
Ms. Canterbury's answering or shaking her head no.
There's a clear
Did you want to respond?
I understand from the interim policy that there's a legal review on whether or not to conduct the surveillance, but once the information is collected, it is Mr. Harris who maintains that and determines who gets to use that information and how it's used. And so my recommendation is that the COO shouldn't be involved, as you suggest, sir. I think it may be a conflict of interest. He should not have a part in all decision-making and then control what the information that is collected at the back end. Certainly at the back end, there has to be a legal review to make sure.
So you don't think that even though what he cited as and considers as another step is not really doing the job because of, again, just the nature of the conflict of his having both of those responsibilities? I mean, I don't want to put words in your mouth. Is that correct?
Right. My concern is with after the information is collected, what happens to it? Are there protected disclosures swept up in what is collected? And only Mr. Harris would get to decide that, according to the interim policy.
Well, I think, again, we've stated earlier that the policy is nowhere near complete. We made a conscientious choice to have an interim policy so that we can get this right. And this has to be done right over time. There are many scenarios that apply here that don't have a single answer to it. The other piece of it is that we want the agency to begin to move forward and, one, again, protecting whistleblowers, two, making sure that our processes are commonly understood from end to end, and then at the end of the day, before anything begins, we have to have an approval. And so I don't know what happened again 2 or 3 years ago, but I know now that we have a much more well-oiled process. It is interim. It's not perfect. We have to build it as we go because, as Mr. Cummings said earlier, the landscape changes with IT on a regular basis. We have to be fluid with it if we're going to stay on top of things.
But also, again, in protections and making certain that important responsibilities are fulfilled. I think Ms. Canterbury did allude to, again, some conflict that exists just by the nature of the current way this is conducted.
That's right. It comes out of my hands and goes, as we talk about the legal review, we call it a legal tank team. Yeah. When something has occurred that needs to have a set of fresh eyes on it, it comes out of my hands and goes into the hands of a legal team who looks at it, and we call them a tank team. They then decide the best recourse of action from there. So I think it's probably better if we could at some point in time have some conversations about what we're doing, because I think, again, from where we were 2 or 3 years ago, night and day.
Well, again, we wouldn't be holding this hearing if it all worked right, but that's why we're here. Let me turn final question just to Ms. McGee. You're involved in, again, some of the monitoring. Is that correct?
That's correct.
Yeah. And did anyone ever tell you that it was inappropriate to look at disclosures to OSC or members of Congress or attorneys? Did they tell you that?
The focus of the monitoring wasn't on any of those disclosures. While they may have been captured broadly, it was not something that we looked at.
Okay. And did you think that it was fair game because they were doing it on an FDA computer, that they could, again, look at that information and make the disclosures?
I'm sorry, I don't understand your question. They could look at it?
Again, you thought it was fair game because they were using an FDA computer in the process.
The software that was used captures everything, is my understanding. There was not a way to wall off different communications, types of communications.
Well, again, but you thought it was appropriate use of computers and information?
I'm not getting your question. I'm sorry.
Again, you've said to the committee that you were involved in this process.
That's correct.
And you, in fact, has said that it was inappropriate to look at disclosures, or you said there was not a problem with looking at disclosures to either OSC or members of Congress or attorneys, is what some of the information I've been provided. That's not correct?
I don't believe that's correct, sir. It may have been a misspoke during an interview.
Well, again, I'm looking at information that was provided from your transcribed interview, and furthermore, when questioned about this, I'm informed that you thought it was fair game because they were doing it on an FDA computer. And I think you responded, at least in those interviews, you thought it was a fair game because, again, they were using FDA computers.
If I recall, I'm trying to put your question into context of the question I was asked. I believe monitoring FDA employees' computers is fair game.
Is fair game under the rules. You still believe that?
I believe there are times when it is appropriate, yes, to monitor FDA employees' computers.
Okay. And about what about disclosure of that information? What's your feeling about what's taken place and how that's worked? Well, there have been disclosures from the monitoring that are inappropriate, and obviously the monitoring again monitors people's inappropriate activity. That's part of the purpose of the monitoring, correct?
That's correct.
Okay. And what is your opinion as to how this has worked and functioned? You said it's fair game, which they're doing. They're conducting this this monitoring. And obviously, we've had problems with it not working. What is your opinion? What's the flaw? Where do we need to go?
I certainly believe the processes that the agency has put in place in the last 6 months would have helped in the situation.
If it had been in place.
If it had been in place in 2010, it certainly would have helped.
Okay. All right. Thank you. Yield back.
Thank you. At this time, I'd like to thank all of our witnesses for taking time from their busy schedules to appear before us today. The committee stands adjourned. Thank you very much. Thank you. Okay, all done?
Yes. Thank you, sir. Appreciate it.
You sure my questions were okay?
Yeah. Microphone is still on.